morning, everyone. Thank you for joining. Rob Bonta, California Attorney General here. And as my colleagues come up, let me just first say I want to thank the Feminist Majority Foundation for hosting us today, including Executive Director Catherine Spiller and the Director of the Foundation's National Clinic Access Project, Duvern Gaines. Thank you for hosting us. We're honored to be here. Thank you. We're here today to announce action my office has taken to hold the city of Beverly Hills accountable for illegally interfering with and ultimately preventing a new reproductive health care clinic from opening right here in Beverly Hills. In my opinion, this was an intentional effort to violate the law, multiple laws of the state of California, a state that prides itself in our commitment to reproductive freedom, in being a sanctuary for reproductive health care. As other states roll back their protections, their access, their commitment to reproductive health care, California has moved forward. That is who we are, that is what we stand for, and that is the law. There are two separate provisions of the state constitution that Beverly Hills violated. Article 1, Section 1, and Article 1, Section 1.1. They have also, in addition to violating the Constitution multiple times, also managed to violate state law when it comes to the Reproductive Privacy Act. This is all set forth in our complaint, and it didn't have to be this way. Beverly Hills could have just done nothing and sat back and allowed an arm's length business transaction between two entities, a landlord and a tenant. A tenant who was seeking a lease actually signed a lease with the landlord to provide reproductive health care. And instead, the city of Beverly Hills went out of its way, inserted itself into that relationship and engaged in a number of different types of conduct, including delaying the permitting process and then launching a pressure campaign against the landlord until the landlord rescinded its lease with the tenant. Again, it didn't have to be this way. And we had the mayor at the time directly involved, the city manager, the city attorney, the police chief. And through their conduct, they violated California law. And when you step back, you might say, I am somewhat surprised that we're here. This is California, a beacon of light and hope when it comes to reproductive freedom across this country. We're here in Beverly Hills with an iconic city right here near Hollywood. And it's a stark reminder that you don't have to be Texas or a red state to be a place where reproductive health care is under attack and threat. It can happen right here in California, unfortunately, so we must be vigilant. And in my office at the California Department of Justice, we are. We will use the full force of the law, the full authority of our office to make sure that the constitutionally enshrined protections to reproductive freedom, the statutorily protected rights when it comes to reproductive freedom, that they are protected, and that cities like Beverly Hills do not deny those rights or interfere with those rights, as they unfortunately did here. So we have a stipulation in judgment that we filed yesterday. We're proud of the work that we accomplished through my great team's efforts and culminating in the stipulation and judgment. We've also filed a very detailed complaint that shows chapter and verse, action and words, what the city of Beverly Hills did. And I think that's the best place to look to see what the truth is here. You will see spin, you will see denial and deflection. You've seen it already from Beverly Hills. The most important place to look is their conduct, their actions, their words. They must own that conduct. They must be held responsible for that conduct. And with today's announcement and lawsuit, that is exactly what is happening. Let me just say a few words about Proposition 1 from 2022. It was California's response to, in part, to the Dobbs decision, which, as you know, rolled back and stripped away a right that the Supreme Court had recognized for over 50 years. And in California, we said, we're not going back. We're moving forward. We will enshrine in our state's constitution the right to reproductive freedom and the right to contraception. And that is the basis, one of the three bases of our lawsuit today. Some people at the time thought, hey, this is symbolic, this is California. It's not just symbolic. It is real. We are holding cities accountable who violate Proposition 1, and this is an example of us doing exactly that. It's an example of California showing what it means to be a reproductive freedom state, to protect the reproductive freedom of our people. And before I get too far ahead of myself here, I do want to take a pause to say thank you. Thank you to my team. I want to acknowledge the members of my team. I'm about to embarrass them. But I want to recognize them. They don't do it for the acknowledgement, the recognition, the credit. They do it because they are mission-driven. They know this is important, and they want to protect Californians who they may never know, who may never know them. But they're here, and I want to recognize them, particularly members of my Department of Justice's Healthcare Rights and Access team. This is just another example of the great work that they've been doing month in and month out, year after year. And they are why we are here making this announcement possible. Specifically, Senior Legal Analyst Wendy Harrison, Deputy Attorney General Erica Connolly, Supervising Deputy Attorneys General Carly Eisenberg and Natalie Torres, Senior Assistant Attorney General Nellie Palma, and Special Assistant Attorney General James Toma. Thank you to my team. You know, let's just step back here in the timeline and go back to around when the Dobbs decision occurred. I know for many of us, a gut punch and something that was painful and traumatic. And many folks in California stood up and pushed back against that decision and took appropriate legal routes within the contours of that Supreme Court decision to strengthen reproductive freedom and access to reproductive health care in California. And interestingly, Beverly Hills was one of those entities who decided to make a statement. They unanimously adopted a resolution in support of a woman's right to choose an abortion. That was their stated position. That's what their words said. Unfortunately, it seems now, in retrospect, having seen what they then did, that that was more show than substance. Their actions speak louder than their words. And while they were speaking about their commitment to a woman's right to choose, they were acting to undermine that very right to choose that they presumably supported. And they worked really hard to undermine that right. Again, they could have just done nothing and allowed DuPont Clinic, which is a well-regarded abortion provider network based in Washington, D.C., to, in 2022, lease a space from the real estate company Douglas Emmett to open a reproductive health clinic in Beverly Hills and then start operations. That's what they should have done if they were going to follow the law. But they didn't. Shortly after the news of the clinic became public, anti-abortion protesters turned up at a city council meeting to voice their opposition, not uncommon. We have a commitment to the First Amendment, the right to expression, to petition your government, to express your grievances, and we have seen this before. After taking heat from the anti-abortion protesters, city leadership began that two-pronged strategy to interfere with DuPont Clinic's opening with the clear end goal of shutting down the deal, of blocking it, of not allowing them to come to Beverly Hills. First, the city intentionally delayed the permitting process to slow things down. Then it launched that pressure campaign against the landlord, Douglas Emmett, to persuade the real estate company to end the contract, again, which it did. They were successful in their pressure campaign. They were successful in their efforts to violate the Constitution and the laws of the state of California. And there are rights to reproductive health care access in California, and the Beverly Hills, in a nutshell, violated those rights. You can't have access to reproductive health care if you don't have providers providing reproductive health care. They interfered with that access by not allowing an abortion health care and reproductive health care facility to come to Beverly Hills. And while we are here today, because we've come to an agreement with the city to resolve their illegal actions and prevent further violations, we have very strong and robust injunctive relief where there will be trainings and a designated officer and reporting to us where the city of Beverly Hills will submit to our oversight their efforts to comply with the Constitution and the law of the state of California going forward. While that is all good news and that is important, I can't but express my deep disappointment in the fact that we had to be here at all. And it's more than disappointment. It is anger and it is frustration that the DOJ had to get involved. We shouldn't have had to get involved. Governments are there to uphold your rights, defend your liberties, protect you from others who might seek to violate your rights. They're there to give you safety, including public safety. And the reprehensible actions of Beverly Hills were exactly the opposite. They undermined and stripped away and harmed. They interfered with and denied the rights that the state constitution and the California state law has given. They threatened to withdraw public safety resources and deprive a clinic that would have been operating safely and legally of public safety protections. And these are individuals who took an oath to uphold the laws of the state of California, including its constitution. And so they failed in their duties, and they did not fulfill their responsibility. And again, this is, unfortunately, proof positive that the challenges to abortion access and reproductive rights are not just happening in those red states. They're happening here, and we must be diligent. We can't, and vigilant. We can't just say this is a somewhere else problem. Unfortunately, this is a right here problem. And the threat to reproductive freedom is pervasive, even here in California, and we cannot allow that threat to win. Local communities must follow the law. It's that simple. They should be doing their part to make reproductive care more accessible, to welcome more providers, to make businesses and patients feel safer. And so let this be a lesson to all communities who may be contemplating similar actions to those that Beverly Hills took. If you infringe on Californians' reproductive rights and reproductive access, you can expect the DOJ to be at your door. You can expect to hear from me and us. We will robustly and vigilantly and aggressively defend those constitutional rights that the people of the state put into our state constitution, that the legislature put into state law representing the people of this state. So let me get into a few details, because it's important to look at the actions, the details, the conduct with specificity. And let's start with the delayed permits. The Beverly Hills City Attorney stepped outside the bounds of his typical job description to intentionally hold up the permitting process, the permitting for the healthcare facility. He did so under the guise that he needed to confirm the clinic would only provide legal services. He took that on as his duty and responsibility, a politicized, unsubstantiated, frankly offensive delay tactic. And this wasn't business as usual. This isn't something the city attorney of Beverly Hills does, going out and before a permit issues seeking indicia of reliability on legal prospective action. For any other business, the permit would have been processed and approved quickly per city protocol. But the protocol was intentionally departed from. In fact, the city attorney even admitted at one point that if this had been a plastic surgery practice, he would not have gotten involved. But because it was an abortion clinic, he got involved. All of this amounts to clear discrimination against DuPont Clinic because it is an abortion provider, which is illegal. Now, the second piece, the pressure campaign. The mayor, the city manager, and the police chief worked together to scare and intimidate Douglas Emmett out of the deal. A deal that was concluded, finalized, consummated. A 10-year lease was provided to DuPont by Douglas Emmett. They improperly, and the city of Beverly Hills improperly and inaccurately claimed that a new DuPont clinic would cause security threats against its other tenants. They made the unsubstantiated claim through their fear-mongering that the building would be subject to protests that include bomb threats and lone wolf active shooters. There was no indication of any bomb threat. There was never any bomb threat. There was no lone wolf shooter threat, no evidence, no indication of that. But they wanted to drum up that possibility or likelihood or threat. In one meeting, the mayor claimed the clinic would be a lightning rod for Beverly Hills and that it would create negative media attention. Again, the city had no evidence of such threats. It was a completely baseless claim, simply meant to strike fear in the real estate company. And again, it worked. To make matters worse, the city said they'd be so overwhelmed by these imagined, unsubstantiated threats that they'd be unable to provide resources to the landlord and the building, threatening to abandon their sworn responsibility to uphold public safety. And mind you, this clinic, DuPont Clinic, would be fully acting within the law, acting within its protected constitutional and California statutory rights. And the city said that they would withdraw public safety resources from a law-abiding, constitutionally protected clinic operating in its city. The mayor went as far as saying that Douglas Emmett would be responsible and liable if anything happened as a result of the clinic opening. When the initial manipulation tactics didn't work, city leadership threatened to send a letter from the Beverly Hills Police Department to all of Douglas Emmett's other tenants in the building, warning them about the threats posed by the clinic, the disruption of business that they would face if DuPont became a tenant along with them in the building, the risk to public safety, the potential criminal activity. They had a plan to send this letter to scare the other tenants of Douglas Emmett. And again, not at all business as usual, not something that's done as standard practice in Beverly Hills. In fact, a letter like that had never been sent from the city or police department before. One draft version of that letter warned about public safety concerns, increased noise, and pedestrian traffic due to protesters, violence or acts of vandalism, harassment, intimidation. It was a long litany of of evils and bad things that were going to happen to those tenants if DuPont came in and operated safely and legally in California. Again, this is all despite the fact that the city had no evidence, the city had no intelligence about any specific threats. But that wasn't enough for the mayor. That was not enough for the mayor, who said in response to the draft letter, "I don't mind turning up the heat a little." His own words, turning up the heat on Douglas Emmett. At one point, DuPont Clinic expressed concern that the letter would cause disproportionate anxiety and asked for the city to include the precautions that the clinic was already taking and the protection tenants could be legally entitled to, including the protections of both federal law and state law, the Federal FACE Act, the State FACE Act, which protects those accessing reproductive health care facilities from violence, threats of violence, intimidation. After receiving the clinic's comments, the city manager privately emailed the police chief saying, quote, "The letter is ours, and this is not a collaborative process." Presumably not interested in including references to state law or federal law or the precautions DuPont Clinic was already taking. It's clear that city's leadership was not interested in the clinic's input, wasn't interested in their expertise or their experience in this matter. It's evident that the city wasn't concerned with protecting DuPont from these supposed security risks that they drummed up. The city saw DuPont as an annoyance to be dealt with, and they wanted them out. At one point, the chief of police even referred to the clinic as a, quote, work pill, meaning they would create more work for Beverly Hills PD. And mind you, this is a clinic that is operating safely and legally, and it is other people, protesters and perhaps those who might cross a line from lawful to unlawful activity, who would cause any need for the police department to get involved. The city of Beverly Hills saw a lawfully, constitutionally protected business operation as the cause, the creator of their problems, instead of the recipient of other people's conduct, the victim, if you will, that needed and was deserving of and lawfully entitled to public safety protection and protection of their constitutional and statutory rights. They got it completely wrong. When Douglas Emmett didn't seem to be capitulating to Beverly Hills, the city did indeed turn up the heat, just as the mayor said, threatening that it would be sending the warning letters to its tenants imminently. Get ready for us to send the letter, with or without the cooperation of DuPont. The city even threatened to have uniformed police cadets hand deliver the letters. Can you imagine being a tenant in a building, getting a knock on your door from a uniformed police officer that gives you a letter saying your operations are going to be disrupted, your business is going to be undermined, your safety is at risk because of another tenant that might be coming into the same building? That was their plan. An extreme and alarmist move. When the landlord asked the city to pause plans for the letter, the mayor gave them 1 week. The landlord knew what was going to happen if that letter went out. The pressure campaign was working. In that week, Douglas Emmett decided to end its contract with DuPont Clinic. It rescinded and withdrew from and revoked a 10-year lease that had already been inked, stating that the letter planned for its tenants that the city was going to send, that police cadets were going to personally hand deliver, was part of the reason. The real estate company told the clinic that the city had put them on notice. Following the end of the deal, city leadership ran back to the anti-abortion protesters, to assure them the clinic was no longer moving in, a clinic that had every right to move in, whose operations providing access to reproductive health care were protected by state law and the Constitution. It's abundantly clear that the city interfered because the clinic was going to provide abortions. Again, none of this treatment if it were a plastic surgery center, only because it was an abortion clinic. City leadership saw the clinic as nothing more than a potential source of disruption that they did not want to deal with. So they meddled in a legal and legitimate business arrangement, discriminated against a reproductive health care provider, and violated in the process both California Constitution's protection for reproductive care access and the Reproductive Privacy Act. They managed to go out of their way and do a lot when it comes to violating state law, none of which they had to do. They could have just sat back and allowed the two parties to negotiate their lease. And this is not what California stands for. California, again, is a beacon of reproductive freedom, a beacon of hope when it comes to what is possible for liberties and choice and bodily autonomy. And as Attorney General, I will continue to protect that freedom with the full force of my office. This stipulated judgment is proof of that. The City of Beverly Hills has agreed through this stipulated judgment to robust injunctive measures that will ensure they aren't able to stymie another reproductive health care provider from opening. Beverly Hills has agreed to train city employees about state and federal protections for reproductive health care clinics within 60 days of this agreement and every 2 years after. They've agreed to post those trainings publicly so we will all know what they are training their employees about. They must create a procedure for individuals to report violations of reproductive rights. They're required to appoint a reproductive compliance officer to oversee this work, and they're required to provide annual reports on their compliance for 5 years. This agreement is a step in the right direction, but again, it should never have been necessary. We shouldn't have had to be here. Today is just the latest example of California DOJ's efforts to protect reproductive justice. This year, I was also proud to support Assembly Bill 2085, which was signed into law just last month, kicks in terms of its effectiveness on January 1st. This new law will streamline the future development of reproductive health clinics and prevent injustices like this one that we're discussing today. Last month, we filed a lawsuit against St. Joseph Providence Hospital in Eureka, California. Again, another example, unfortunately, of reproductive freedom being under attack right here in the great state of California. We filed a lawsuit against them for illegally refusing to provide emergency life-saving abortion care to a patient, turning her away at great risk to her health and her life. Last year, we filed a lawsuit against a chain of 5 so-called crisis pregnancy centers for misleading patients about an unproven, risky, experimental protocol called abortion pill reversal. These are just a few examples of the work we're doing to safeguard abortion access, and we're not done. We will do whatever is necessary to enforce the law, to protect the constitutional rights of Californians, to ensure that there is access to reproductive health care for the providers who provide it and the patients who receive it. That's what Californians want. That's what the law requires. And let me just close by simply reminding local communities across the state, abortion care is health care. Reproductive health care is health care. In California, reproductive health care is a constitutionally protected right. As Attorney General, I promise to always stand up for a patient's right to make their own health care choices for their own bodies. I will always stand up for a provider's right to provide care. And I will always fight for reproductive justice and do everything in my power to ensure California remains a beacon of reproductive freedom.